Joining me now, CNN legal analyst and criminal defense attorney Joey Jackson and professor of law at Brooklyn Law School, Alexis Hogue. Counselor, let me start with you. How do you assess the decision to put Kyle Rittenhouse on the stand and the results?
All right. In terms of the decision, we always know that when you put a defendant on the stand, there are complications, right? So you have to make a calculated decision as to whether it's appropriate to do that. It really is a risk. Having said that, I thought it was very effective. I would say from a defense perspective, it was excellent. Why do I say that? Three factors. Number one, you want to demonstrate that your client is a human being. We saw that with the sobbing. Now, people will assess that and say they were crocodile tears, he wasn't doing this, his comportment, whatever. I thought that from a human perspective, you want to establish that this is an individual, he has feelings, he has emotions, and he didn't want to do it, he had to do it. Number two, John, you look at what he said. You have to, when you are in a self-defense case, explain to the jury and justify what your actions were. He did that in every regard. How? He talked about the fact that a pistol was pointed at his head. What else am I to do? He talked about getting ripped like a baseball bat with a skateboard. And so he needed to do what he had to do from that perspective. And then he talked about, with respect to the other person, the rifle, the grabbing for the rifle. So I think he did that. Final point. The final point is that he turned himself in thereafter. We as lawyers always talk about this notion of consciousness of guilt. What does that mean? It means I did something wrong, so I ran away, I'm hiding, I'm concealing myself. He turned himself in. That goes to the fact that he felt at that time he did nothing wrong. I think on balance, it was very effective, risky move, but I think in this case it worked. That's my assessment.
I will say, and I don't mean this by means of praise or pejoratively, he was extraordinarily well prepared for this. It seemed as if he had gone over each and every aspect of this case multiple times and was surprised by nothing. But Professor, if you're in the jury, how do you think you perceived that emotion?
Yeah, as Joey said, you have got to put your witness on. You've got to put your defendant on if you're alleging self-defense. And so the jury needs to see how he operates. And I think his display of emotion, we may have a variety of reactions to it, but the jury has to believe that he reasonably felt in fear of his life, and that's why he used lethal force. And in terms of whether or not someone is reasonably in fear of their life, that's a subjective analysis. And so when we saw him display high degree of emotion, he got extremely anxious, he couldn't speak, it allowed the jury to see maybe this person as a 17-year-old was in fear of his life, even if objectively another actor in a similar situation wouldn't have been. So it's actually quite critical, that display of emotion. Whether they were crocodile tears or not, it allows the jury to then assess subjectively what his fear of the risk potentially of his life.
Also, the jury only sees it once, right? We can rewind and watch it again and try to assess, oh, were there tears or not tears? They see it once.
Exactly.
Let's talk about the judge. Actually, let's play this because I've never seen anything like this before, where a judge yelled quite like this. Oh, we don't have it. But you saw the judge going bonkers there. On the law, Professor, the judge's concerns.
So I teach evidence this term, and I will talk about this case in a couple of hours when my class meets. And what we talk about throughout that course is that the judge has a high degree of discretion. The judge is sort of the almighty in that courtroom. No one is going to question his behavior. No counselor, no advocate is going to question what he's doing. And I think we have seen this before, and we've seen it on Shonda Rhimes shows. We've seen it on How to Get Away with Murder. This is not what we're used to seeing from an officer of the court. And I don't know how effective with in the whole scheme of things, what the impact of the judge's behavior would be. The only appeal here would come from Rittenhouse if he is convicted.
Yeah, the prosecution can't appeal. The legal issues he had, Joey, performative issues aside, were the prosecution was getting into the propensity to commit a crime, which I know from professors like you is a problem.
It is.
And also the constitutional issue of the right to remain silent. So how close to this third rail was the prosecution?
Extremely. And I think that they exceeded that. And let me just come back from a practical perspective. As a practitioner in this state, as a person who is in courtrooms and who deals with judges, this is what happens, right? This is televised, so we get to see it. Judges do this. And whether it's to the defense attorney taking you to task for doing something with respect to disregarding a ruling that the judge made, we talked about this before. It's the judge's issue. You had a motion on this issue. We agreed that this would not be stated, and if it was, you would have talked to me. Judges, and he had a right, in my view, to say what he said. And in terms of look, you have a right against self-incrimination. You're really going to cross-examine someone as a prosecutor on the defendant not saying a word? Well, guess what? I'm allowed not to speak if I don't want to speak. You cannot use that against me, and that's a problem. And to the issue of propensity evidence, you can't talk about the issue of because you did this, you would be inclined to do it again. And I think regardless of the criticism, I'm with this judge. I've been ripped apart before. I've seen attorneys being ripped apart before me. I'm not immune to it. Attorneys aren't immune to it. When you're in the court, you behave yourself appropriately, you follow the rules, and when you don't, get prepared to be undressed by the judge, and he did that.
Got time for basically a one-word answer. On balance, did Kyle Rittenhouse help or hurt himself yesterday?
He helped himself.
Helped very much.
What are you looking for today?
I'm looking for the defense to continue to lay out the issue of why it was self-defense. And if they could establish the immediacy of the fear, the reasonableness of his conduct, and the proportionality of his actions, I think that they're on their way.
Any way for the prosecution to fix what happened yesterday?
Ooh, this use of force expert, that's where they need to focus their attention on. Because if they can establish that it was unreasonable for Rittenhouse to fear his life, if the proportion of his shooting those three men was disproportionate, and then also if he provoked the attack. So I'm going to look for those three things with the prosecution's case.
Counselor, professor, I'd love to sit in on your class later today. That's going to be
10:45.
That's going to be some
there.
class today. Thank you both for being with us.